Our second speaker in the program, whose name has been mentioned several times already as the intellectual force behind the symposium this year, is my good friend and colleague, Bob Adler, who is the Associate Dean for Academic Affairs here at the College of Law, and who also holds the James I. Farr Chair at the law school. His topic is Whither the Compact. Is the compact resilient enough to meet future challenges? And as Patty Limerick alluded to earlier, Bob has coming out within literally weeks a book on restoration of the Colorado River, and you have a flyer on that in your program, and I can unabashedly promote it on his behalf. Please join me in welcoming Bob Adler.
Thank you very much, Bob. Let me add my welcome to all of you today. I've been looking forward to this event for quite some time. Thank you to Patty for a very stimulating and entertaining opening set of remarks. I put myself in a precarious position by following Patty. I did so intentionally because I thought it was unfair to expect any of the other speakers to follow her entertaining speaking style. So onward into the breach. And thank you, both Patty and Bob, for plugging my book. That means that I don't have to shamelessly stand up here and do so myself, although I suppose I just did. My main role this morning is to try to set the table for this multi-course feast that we're going to have over the next 2 days, and I hope you'll agree with me that it's a very satisfying and filling banquet of ideas. What I want to do is to try to give you some background on the history and the purpose of the Colorado River Compact, and then to lay out some of the main arguments both for and against efforts to reconsider its provisions. I do so with some apologies to those of you who are longtime students of the law of the river. It will be oversimplified. I want to make sure that we're all pretty much on the same page as we begin. And over the next 2 days, we'll learn a lot more detail from experts from a wide range of backgrounds and some very talented speakers. Over 3/4 of a century ago, at Bishop's Lodge in Santa Fe, representatives of the 7 Colorado River Basin states met with Secretary of Commerce Herbert Hoover to negotiate allocation of water from the Colorado River, lifeline of liquid wealth then and now for the 7 basin states and for our 2 sister states down in Mexico. The meetings culminated in the 1922 Colorado River Compact, the first interstate compact to allocate an interstate river. The compact itself is brief, but it generated tens of thousands of pages of associated documents in the form of an upper basin compact, statutes, regulations, contracts, Supreme Court and lower court decisions, all of which we somewhat affectionately know as the law of the river. We're here to discuss the resilience or the permanence of the compact. Is it etched in stone? Can it be changed at will? Or is it something in between? What conditions and circumstances, if any, justify changing a document which has been so important to the law and development of the Southwest for so long? Now, there's been some scholarly debate about whether a compact, an interstate compact, is more like a treaty or more like a contract for purposes of efforts to change the agreement. Contracts and treaties can be changed, either by mutual consent of the parties or more rarely by judicial decree when circumstances dictate that it's appropriate to do so. Some have suggested that the Colorado River Compact is more like the Bible, or at least like the Bible of Colorado River law, and it should be defended in its current form with somewhat crusade-like fervor. I want to take a middle ground. I want to argue that the compact has a character and resistance to change similar to that of a constitution, although I'm certainly not arguing that it has the same legal status as a constitution. It's brief, It's written in terms designed to address only the broadest of issues, with details and implementation to follow. Because of the Compact's very broad language, it's open to conflicting and varying interpretations. It's organized into articles and sections, and it establishes both a core organizational structure and fundamental principles of governance. The Compact allows but imposes barriers to amendment, and its stature and history defies even the suggestion of substantial change, as opposed to perhaps incremental tinkering through the implementation documents. So all of those attributes make the Compact seem more like a constitution than like a contract or even like a treaty. But the constitution-like character of the Compact cannot justify the concept of complete rigidity in the face of significant changes in circumstances since the Compact was signed. After all, we've amended the United States Constitution 17 times in the past 216 years. That's not including the original 10 Bill of Rights, which were, of course, adopted contemporaneously. By contrast, the Colorado River Compact has never been amended in its 85 years, despite very significant changes in the population, the economy, the culture, and the environment of the Colorado River Basin. So unless you subscribe to this biblical model, the real issue for the next 2 days and beyond is whether circumstances have changed sufficiently over the past 85 years to justify rethinking this monumental document. The West is a very different place than it was in 1922, as Patty so eloquently instructed us. Population has grown dramatically and continues to do so. Demographics have shifted from rural to urban, and the economy from the agricultural to other sectors. We know more about the river's hydrology and, in particular, its variability than we did when the Compact was drafted. We know a lot more about the impact of water use on the river's ecological and other resources, and public values about the importance of environmental resources have changed with that increased understanding. So is the Compact resilient enough to address those changes, or is it ripe for some reconsideration? There are several compelling arguments in favor of the Compact's resilience, and I want to begin there. First, agreeing on changes would be difficult and contentious. Despite very powerful incentives to reach an amicable agreement in 1922, the negotiations nearly failed and succeeded only through a somewhat last-minute compromise that achieved the original negotiating goals only in part. Although the 7 basin states signed the document in Santa Fe, it took many years for the legislatures of 6 of the 7 basin states to ratify the agreement, and Arizona, the 7th state, did not do so until 1944, as most of you know, following a series of efforts by that state to undermine the Compact in the United States Supreme Court. So given that fragile history, it might be foolish to reopen the Compact now. Changes might be accomplished more easily through other components of the law of the river. And the constitutional nature of the Compact, its very breadth, might provide sufficient flexibility to avoid the need to reconsider the underlying text. Second, the fact that Compact implementation has required such a complex statutory, administrative, regulatory, and judicial appendix suggests that redrafting the Compact would generate immense ripple effects throughout virtually every other component of the law of the river. If we redraft the Compact, we also have to revise much of the rest of that intricate body of law which has taken so many decades to develop. Now, I have to say that's probably good for law schools that train water lawyers, but otherwise it's going to generate an administrative and judicial nightmare. Third, perhaps most significantly, the Compact and its associated body of law has generated such significant reliance on the part of so many public and private parties that any major change will prompt cries of both unfairness and adverse economic and other consequences. Water users from Denver to San Diego rely on the stability provided by the law of the river to plan and sustain farms and ranches and urban development and extractive industries and other endeavors. But our legal and political system also has to reflect and respond to change. So in my book, I illustrate this concept by comparing two seemingly unrelated events. On July 1st, 1999, Interior Secretary Bruce Babbitt, the governor of Maine, and thousands of observers watched from the shores of the Kennebec River as workers breached the Edwards Dam, a structure that had stood for some 163 years. The goal was to restore one of Maine's long-lost runs of Atlantic salmon. 2 years to the day earlier, the sun finally set on the British Empire as troops from the People's Republic of China marched into Hong Kong, and a peaceful modern invasion transferred sovereignty from the colonialists to the communists. After intensive negotiations, China agreed to keep Hong Kong's capitalist economy, to guarantee some political autonomy for about 50 years, and to maintain private property rights and political freedoms. So what do these two unrelated events have in common, and what do they have to do with the Colorado River Compact? Both represent examples of how societies deal with changes in settled expectations. Both reflect how difficult it is to anticipate the long-term impacts of our current actions and policies. When Imperial China signed treaties with granting Great Britain 90% of what's now known as Hong Kong, neither party knew how much the world would change over the next century. Britain believed that it would retain its political and military power to keep Hong Kong after the treaty term, the original 99-year term, expired. Neither party predicted that the small trading post for British merchant vessels would become a global economic powerhouse. Neither side predicted that the nascent ideas of Karl Marx would create an international schism, and that Hong Kong would later be transferred from one side of the geopolitical fence to another. So the British built this whole society in Hong Kong premised on the assumption of stability. Likewise, when Edwards Dam was built in 1836, no one knew that the bountiful Atlantic salmon populations would plummet throughout the eastern seaboard. No one knew very much about the environmental impacts of a single dam, much less the huge system of dams that we would build on America's rivers. No one knew that the ideas of John Muir and Aldo Leopold and Rachel Carson would change American values and environmental policies so profoundly, or that laws like the National Environmental Policy Act and the Endangered Species Act would follow those value shifts. We built dams on the premise that the law would provide stability and that investments would be protected. The same ideas apply to the Colorado River Compact. But to grasp that, we need to understand more about what the compact does and how it works. The compact allocates water usage among the upper basin and the lower basin. The artificial dividing line is at Lee's Ferry. I can't really see this here. Do I have that right? Roughly in between about 16 miles downstream of Glen Canyon Dam. This is roughly the dividing line between the upper basin and the lower basin. So the upper basin is parts of Utah, Wyoming, and Colorado, small parts of northern Arizona and New Mexico. The lower basin is California, Arizona, New Mexico, a small corner of southwestern Utah. The compact actually distinguishes between the upper division and the lower division, and the upper basin and the lower basin, but we're going to ignore those legal details. But as you see, they're not really separate river basins. Lee's Ferry is roughly halfway between the beginning of the river at the headwaters of the Green in Colorado and its terminus in the Sea of Cortez. And it was a logical place to measure water flows between the two subbasins. By the second decade of the 20th century, the lower basin states, especially California, were far ahead in the race to secure Colorado River water rights under the prior appropriation doctrine of Western water law, first in time, first in right. Under this principle, Those who divert water for a legally recognized beneficial use obtain a water with a priority date based on that time of first diversion and use. In times of shortage, those with an earlier priority date or senior rights holders can withdraw all of their water before the latecomers, the junior right holders, receive any. Now, in 1922, the U.S. Supreme Court ruled that prior appropriation applied to interstate water disputes. So water diversion and use in California, especially in the rapidly growing agricultural mecca in the Imperial Valley, ensured that California would have Colorado River water rights senior to the other basin states, which were much slower to develop. California, however, lacked the financial resources, the money necessary to build the dams and canals needed to store and to transport more California River, that's a sort of a Freudian slip, isn't it? More Colorado River water, or to protect California's low-lying farms and communities when the river overflowed. Congress viewed an agreement between the basin states as the prerequisite to investing in that hardware. So California and the rest of the lower basin agreed to reserve a large chunk of the river's flow to the upper basin states. That paved the way for federal financing and construction of what we now know as the Hoover Dam and a major new canal to the Imperial Valley. So California secured more liquid water, flood control, hydroelectric power to fuel urban growth in Southern California. The upper basin states received guaranteed future rights to whatever water, for whenever water development did occur, thus creating a major exception to the prior appropriation doctrine. That was the crux of the deal. That was the fundamental bargain between the upper basin and the lower basin, and here's how it works. According to the most basic reading of the compact, and you'll see that this is my Cliff Notes version, I acknowledge that this is highly oversimplified, each basin has the right to beneficial use of 7.5 million acre-feet of water a year, with the lower basin also entitled to use another million acre-feet in surplus years when more water is available in the lower basin. An acre-foot, by the way, is the amount of water, logically enough, needed to fill an acre of land to 1 foot of depth, or about 326,000 gallons. In return for its deferred development rights, the upper basin, and this is the key operative provision of the compact, agreed to deliver enough water to fulfill the lower basin's entitlements, plus half of the U.S. treaty obligation to Mexico, which was later fixed at 1.5 million acre-feet a year. So in total, the compact allocates about 16.5 million acre-feet of water a year. To ensure that the lower basin receives this entitlement, the upper basin agreed to deliver 75 million acre-feet every 10 years as a rolling average, plus the share for Mexico. But understanding what this really means requires a better understanding of the uncertainty in the river's annual flow. Annual river flows in the Colorado, historically, before the dams, vary dramatically. According to historical records, from a mere 4.5 million acre-feet a year to a high of over 24 million acre-feet a year. During years in which the river flows are high, the upper basin can satisfy its obligation. But what happens during the dry years? So if the compact had been written so that the upper basin only had to deliver half of all available water to the lower basin, that would have divided the risk of drought equally between the upper basin and the lower basin. But it didn't. By imposing a firm requirement to deliver the entire lower basin share during droughts, the compact can deny the upper basin its full share of water. This placed the risk of drought squarely on the shoulders of the upper basin states unless, and this is the critical unless enough water is stored in reservoirs during the wet years so that the upper basin can meet its delivery obligations and still have enough water to meet its own uses during the dry ones. So that, in a nutshell, was the main purpose for the Glen Canyon Dam, which sits too far downriver to serve most of the upper basin's actual water use needs. The dam and the reservoir behind it also provide hydropower and recreation and other benefits, but the main purpose of Glen Canyon Dam was to serve as a hedge against drought for the upper basin and to provide the lower basin with physical as opposed to purely legal certainty that its share of water would be delivered. So what's wrong with this picture from a 21st century perspective? Compromise seems perfectly reasonable. Each basin got something very valuable, and that's usually the mark of a good deal. But for several reasons, some of which Patty mentioned, but which bear repeating, the compact may not suffice to address all of the changes that have occurred or may occur in the basin. First, the states seriously overestimated the average amount of water available when they negotiated the agreement. The negotiators relied on the hydrological record from 1896 to 1921. This is what Patty mentioned, but I'll fill in the details, when flows averaged almost 17 million acre-feet, from which they logically deduced that they could safely dole out 16.5 million acre-feet per year. But the rest of the 20th century turned out to be much drier. The average flow from 1896 to 2004 was less than 15 million acre-feet. The average flow from 1922 to 1982 was just over 14 million acre-feet. And the severe drought that we experienced from 1999 to 2004 highlighted the risk of shortage. In an analysis conducted for drought management negotiations, the Bureau of Reclamation predicted that Lakes Powell and Lakes Mead may never again be full. For the relatively young field of hydrology, 2 decades of data in 1922 may have seemed adequate, if not luxurious. Now we know that a couple of decades is a blip in hydrological time, and that such a small data set can mask much larger, long-term fluctuations in climate and river flows. We'll hear much more about this from Connie Woodhouse and Nicholas Christensen, but based on tree records, scientists have identified periods of much longer and more severe drought in the basin than anything we experienced in the 20th century. Now, some analysts argue that the compact commissioners were aware of the risk of drought when they negotiated the compact, and they took that risk into account. And I think to some degree that's, in fact, true. But the stakes were monumentally high. The delegates sought a solution which would stand the test of time even as conditions and circumstances changed. When taking a calculated risk, sometimes what we don't know is important as what we do know, especially when adopting a water constitution with an indefinite lifespan. This underscores the perils of making decisions that will affect the fates of millions of people across a broad swath of the United States based on incomplete and uncertain science, or at least without taking that uncertainty into account. Second, global warming adds to this uncertainty about the reliability of basin water supplies. Some scientists suggest that we're already beginning to experience a correlation between global warming and declines in annual snowpacks in the West. Some studies and models suggest we can expect more rain, less snow, more evaporation, and therefore less runoff into reservoirs, thus impairing our ability to meet the compact's obligations. Just last week, most of you probably know, the National Academy of Sciences issued a report suggesting that climate change is likely to exacerbate water shortages in the basin. Third, politics led the compact commissioners to ignore some water needs altogether. And you've heard something about that. Despite Mexico's claim to water for irrigation and other uses, the commissioners denied Mexico a seat at the table, arguing that this negotiation about an international river was purely a domestic matter. And Secretary Hoover expressed the view during the deliberations that Mexico was legally entitled to nothing. So the compact provided merely that if water was guaranteed to Mexico by later treaty, it would be supplied equally by the two basins. And in 1944, based on various other political events, the United States eventually guaranteed Mexico 1.5 million acre-feet per year to be shared by the upper and lower basins. But as I think we'll hear from other speakers later on, 1.5 million acre-feet clearly is not sufficient to meet both the irrigation needs of Mexico and the environmental needs in the river and in the delta. Compact negotiators gave Indian tribes even less consideration. 15 years before the compact was signed, the Supreme Court ruled in the Winters case that in setting aside reservations to support tribes, the federal government impliedly reserved sufficient water to meet the needs of those communities. Yet, despite the knowledge of that opinion, and there were some very expert water lawyers as part of the negotiations, and despite the presence of a large number of Indian tribes along the river, the commissioners made no effort, zero effort, to evaluate tribal needs. Instead, they left the matter largely open by providing nothing in this compact shall be construed as affecting the rights of Indian tribes. Well, this came back to haunt the states in 1962 when the Supreme Court in Arizona v. California ruled that some tribes along the river were entitled to nearly 1 million acre-feet of water. Since then, settlements of other tribal water rights in the basin have doled out nearly another 1 million acre-feet of water. Recently, the Navajo Nation filed a lawsuit designed to force the federal government to recognize and to quantify Navajo Colorado River water rights, and Dale Pontius, at least in his report to the Western Water Resources Policy Commission, estimated that outstanding tribal claims could amount to as much as another 3 million acre-feet of water. Tribal rights don't go on top of the compact allocations. They come out of the individual states' allocations, which of course leaves less for other in-state users. Fourth, perhaps the biggest uncertainty, or the biggest source of uncertainty, involves ongoing efforts to recover endangered species and to otherwise restore the ecosystems of the Colorado River. Colorado once hosted the largest percentage of endemic fish. Those are species that are found nowhere else in the world of any river system in the world. Some of those species are now extinct, and many more species of fish, birds, amphibians, reptiles, and mammals are threatened and endangered. While habitat loss, introduced species, and a lot of other factors contribute to those problems, water is one of the major keys to resolving those problems and to restoring species and their habitats. In negotiating the compact, the commissioners obviously gave no thought to ecological needs. This was 1922. Now, through the ESA, the Endangered Species Act, and other environmental laws, society has expressed a new set of preferences, which were not evident at the time the compact was negotiated. But no one has fully quantified the amount of water needed to restore habitats, when and where, and what constraints that will impose on other users. And again, a number of other speakers will address that in more detail later. But the real rub is the fact that the upper basin states have yet to develop their full share of compact water. So the looming question for all is what happens when we try to withdraw all compact obligations in the upper basin and the lower basin, and meet our treaty obligations to Mexico, and meet tribal rights, and try to restore the river's endangered ecosystems, all when there may be less water to go around than we thought when the compact was signed. So let me close with another comparison I used in the book, which again might seem slightly off point, but bear with me. This time between two natural springs that lie not too far apart in the basin. A display in the lobby of the Southern Nevada Water Authority, from whose director Patricia Mulroy will hear tomorrow, provides a history of water use in that region. Spanish explorers arrived in 1776 at what was later named Las Vegas Springs. Settlers pioneered the Spanish Trail from New Mexico to California in 1829 and named the area Las Vegas, meaning the meadows. For more than a century, the springs supported travelers in very small settlements. The first permanent settlement was in 1867. The first water rights to the spring were filed in 1872, and the original Las Vegas town site was established in 1905. But water from the springs were made available only to town residents. So people lying out or settling outside the town boundaries drilled hundreds of private wells, generating a pumping war on the groundwater basin. But that did not provide adequate warning of the shortages to come. When Nevada ratified the Colorado River Compact, knowing that it would receive a paltry 300,000 acre-feet of water, little did anyone know what a thirsty metropolis would grow around this modest desert spring. By 1947, the groundwater basin was overdrawn. So one of the nation's fastest growing cities remains bound by a deal made when it was a small desert byway. Spring number 2. Not far to the southeast of Las Vegas is Pipe Springs National Monument in the Arizona Strip region north of the Grand Canyon. The journals of the Dominguez Escalante expedition recorded this as the hill that seeped water, and Mormon settlers began to use the springs beginning in the 1860s. The springs used to flow at 10 to 30 gallons per minute, but now they're dry. While the reason isn't clear, the National Park Service speculates that the cause was an earthquake with its epicenter in Southern California. This is my favorite metaphor for water wars in the Southwest. An earthquake occurs in California, and Arizona loses water. So for many years, California has used, as we know, more than as much as a million acre-feet more than its apportioned share of Colorado River water. This was possible because Arizona and other states were not using all of their apportionments. So California is now taking steps to eliminate this excess use, but Arizona recently devised a water banking plan to alleviate some of the constraints that Arizona faces, and to some degree Nevada, under the law of the river. We'll hear more about this from Sid Wilson's, but in essence, Arizona will withdraw its full apportionment of water every year, but because it can't put all of that water to immediate use, it will bank that water in aquifers by storing it in aquifers. Arizona can withdraw some of this liquid currency from the bank in future years when its demand for water increases or in times of drought. So that way, Arizona benefits more fully from its lawful compact apportionment rather than ceding more water to its thirsty neighbor to the west. And Nevada also agreed to help pay for the water bank in return for the rights to use some of that stored water as its needs increase. But note what's really going on. Changes are being designed not to meet existing water needs, as the Queen said, what we need now, but rather to maneuver for maximum future advantage within the artificial constraints of the compact and the law of the river. So the artificial legal construct has become more important than real needs and real economic or ecological realities. The more significant and equally artificial constraint on river restoration derives from the upper basin's rolling 10-year average that I described earlier to deliver 75 million acre-feet of water every year at Lee's Ferry, which again was the dominant reason for the Glen Canyon Dam. Compliance with an artificially defined water delivery at an artificial point along the river cannot, standing alone, justify a structure that causes so much harm to the aquatic ecosystem of the Grand Canyon and downstream all the way to the Sea of Cortez. If the dam stays, if it's going to be justified, it must be on grounds independent of the compact. And if the compact doesn't reflect current realities, it should be reconsidered. And I'm sure we'll hear more about that from Rich Ingebretson later on. All of this suggests a need to reconsider the compact in light of such significant new information and changed circumstances. An interstate agreement of this magnitude should not be revisited lightly. The compact has stood the test of time for 8 decades through periods of drought, periods of flood, and dramatic socioeconomic changes. Significant investments and other decisions rest on the certainty provided by this landmark agreement and its library of related laws and regulations and court decisions and contracts and other legal documents. But we can't simply ignore the current realities that suggest potential reevaluation of the compact. We're asking a lot from a river that is, after all, a desert river in a desert climate. Can it do all we ask of it and still have enough for its native species? I don't pretend to have the solutions to these very complex issues, but I do suggest that they demand much more serious attention, and I hope that the next 2 days will provide some very useful commentary and discussion from a diverse and knowledgeable and very talented set of speakers. Thank you. So we have 6 minutes, 5 minutes and 57 seconds for questions. Bill?
Given the very difficult constraints on formal amendment of the contract which we alluded to, the implication is we have to try to find a more flexible way of addressing the complexities without trying to have the battle royal with the fundamentals of the contract. Who, if anyone, is working on how to define that flexibility? And then I have a second piece of that question, which is, does water conservation fit into that process of reconsideration in a way that responds to terms of the contract?
Okay, 2 questions. One is the implication that we should try to find more flexibility within the compact and other aspects of the law of the river as an easier solution than amending the compact itself. And the second question was, where does water conservation fit in? And the answer is that, you know, if you want to amend if you find a problem within United States law, that's the analogy, you might try statutory solutions first or regulatory solutions first. And I would suggest that people have been trying to do that in negotiating various, the Arizona Water Bank, various water marketing deals, and other flexibility that might be sufficient to address some of these problems. I personally have my doubts that that will be sufficient, whereby you move on to a broader change in the governance principles. Where does water conservation fit in? Certainly in my book, I advocate that the efficiency with which we use water should be viewed as a restoration strategy, and that our restoration strategies shouldn't be limited to efforts to modify the operation of particular pieces of hardware up and down the river, but rather we need to think more broadly about how and where and when we use water and how efficiently we use it. The compact grants the right to the beneficial use of 7.5 million acre-feet of water, and as a matter of water law, beneficial use suggests a lack of waste and efficiency, but as any of the water lawyers in the room know, that principle hasn't been enforced with great stringency in the West.
Do you yourself think it's possible to squeeze 1% of the overflow to restore the delta? Do you see that happening?
Okay, the question is, do I believe that 1% of the river can be used to restore the delta? The origins of that question are that there has been a proposal floating around for 5 to 7 years based on what happened during the flood years of the 1980s, which, based on aerial photographs and other on-the-ground scientific studies, was actually able to flood the banks, overflow the banks of the lower Colorado River down through Mexico and into the delta, and to naturally restore many thousands of acres of habitat along the lower river. So the suggestion is that it doesn't take all that much water perhaps 1% of water to create this natural restoration regime in the lower river? And my answer to your question is yes. I think that we certainly should be able to devote 1% of the river's flow for that restoration purpose. Now, my caveat is that we don't know whether that's sufficient to restore some of the other resources in the Delta and beyond, and Carl Flessa and others will be addressing that later.
Another question, does that mean we could possibly prioritize 1% if we wanted to do that to make that happen? That seems like heating water stuff would make it difficult for that to happen because that would become a management priority. It seems like that might not be difficult.
Well, it would certainly have to be either by agreement or by some other legal mechanism. In the back.
Reconcile that answer with your assertion in the middle of your presentation that $1.5 million per annum is clearly insufficient.
Well, I said 1.5 million acre-feet, which is our current delivery obligation, is not sufficient to meet Mexico's treaty obligations plus environmental restoration needs in Mexico, because essentially the entire Mexican share is diverted from the Morelos Dam just south of the border to agricultural and some urban uses in Mexico. What returns to the Delta is irrigation return flows. So my contention was that it wasn't enough for both. I think we have time for one more question. Yes, sir.
If you think the ecological needs were perhaps a missing partner in the what do you think would propel existing partners to make them more?
Well, I think, for one thing, moral compulsion should be one reason, and that the public's change in environmental values ought to be reflected in the actions of the state leaders over time, perhaps naive, but I do think that's part of it. There is a looming question about the applicability of U.S. environmental law and the relative position of the Endangered Species Act and the Colorado River Compact. And some lower courts have ruled to date that the compact trumps the Endangered Species Act because it limits the amount of discretion that the Bureau of Reclamation has. Yet to go up to the U.S. Supreme Court. I think there are some legal issues to be decided there over time. Thank you.